Let's start. We have guest today, Professor Joan Heifetz-Hollinger from the law school, and this is her topic. I just want to remind you that this lecture fits into discussions that we've already had or that we've initiated. So when we talked about the Universal Declaration of Human Rights and then the 1966 protocol on civil and political rights, we talked about the issue of marriage in that context. It wasn't the issue of marriage with gay marriage, it was the issue of the right to marry someone whom one wanted to. And it was it had considerable objections to it before from some Arab countries, and we discussed this a week ago. Saudi Arabia didn't sign the Universal Declaration. So the issue of the relationship of this seemingly private act of marriage and this seemingly public issue of human rights has been an issue that we've raised before. Then we raised the issue of miscegenation and the very brilliant question. And so today we're going to reach another version of the story, and Professor Hollinger will help us articulate the relationship between these different stories. So she's introduce her. She's a real expert on issues of marriage and family law in general. She's very active in writing briefs on issues of gay adoption, on issues of in vitro fertilization and parentage and having to do with reproductive technologies. She's a leader in producing a uniform national family law code. So this she knows about this stuff. She's also been very active in this particular case and written amicus briefs in relation to it. So I'm going to let her, she'll be in charge. She said she'd like to follow our usual practice of stopping every so often to ask questions. She'll stop herself to ask questions, but if you have something desperate that's unclear as we go along, you should raise your hand. So in other words, the usual rules of engagement apply. Thank you.
Thanks, Tom. This is a great day for a protest, so thank you all for coming here. You can party later or protest later, especially this evening when apparently on the Sproul Hall steps Bob Reich is going to bring wisdom to us all. I actually had always planned to begin with a reference to Hannah Arendt's comments in response to the Little Rock, Arkansas events in the 50s, but to key them in here to the context of establishing as both a civil right and as a human right access to marriage broad enough potentially to extend to same-sex couples. Although it's very easy to fall into the phrase gay marriage or same-sex marriage, and I do it myself, I think it's very important at the outset to keep in mind that within human rights and a civil rights framework, if you begin with a sense that the entry into marriage or a right to access marriage is a fundamental human right, however contested it might be in the international arena, and however contested it has been historically within the United States. If you begin with that as your frame, then I think the appropriate question is not whether gays have a right to set up marriage light or marriage like or same-sex or gay marriage, but rather whether the right to marry is an individual right broad enough to encompass the aspirations of same-sex couples. So I put it that way. I go back to Hannah Arendt, and perhaps when Mark Brilliant was here, he mentioned this to you, but even if he did, I'll repeat it, which is that when Hannah Arendt attempted to publish the article in which these statements appeared, her warning against sort of getting deflected by mere civil rights, the rights to attend an integrated school, the right to sit on the bus where you please, the right to be in public accommodations regardless of race, and so on, she was pointing out that all of these, including possibly the right to education as being somewhat burdensome, something on the backs of little innocent children, were ultimately not relevant and not going to change the course of our civilization in the absence of attention to this more basic human right, the right to home and marriage, as she puts it, keying it not to our Constitution, but to the Declaration of Independence as something that may be inalienable, that may actually exist pre-law. But she was not able to publish or get her article published when she wrote it. She also was trying to get it published at about the same time that Mildred and Richard Loving, who became the plaintiffs in the 1967 case of Loving versus Virginia, where the Supreme Court unanimously struck down the remaining anti-miscegenation laws, about the same time that they were arrested while asleep in their bedroom, as the Supreme Court might say, in the sanctity of privacy of their marital bedroom in Virginia, and arrested by the local sheriff and hauled off to jail, where they were later prosecuted for the crime of having entered into a marriage in Washington, D.C., that was considered void and illegal and criminal within the state of Virginia, which is where they wanted to reside. So just as we're beginning to get the seed sown of the story that then ends up at the Supreme Court in 1967 on the issue of anti-miscegenation, Arendt is peddling her tale. So why couldn't she get it published? She couldn't get it published because sort of the official civil rights leaders in this country, and most specifically the NAA Legal Defense Fund, wanted nothing to do with this suggestion that intimacy, home, and family was ultimately more important, more foundational than the right to vote, the right to public accommodations, or the right to education, the right to employment without regard to race, color, or ethnicity. There were earlier efforts in the late 50s to bring a case before the Supreme Court challenging the anti-miscegenation laws, and more specifically a case called NAME, N-I-A-M, which the leaders of the NAA and the ACLU and all other civil rights organizations stayed away from. They were simply not interested in pursuing this question in the 50s. And indeed, when in Perez versus Sharp, this case from California, in the late 1940s, the California Supreme Court not only struck down our own anti-miscegenation laws, but expressed the right to marry in language that has continued to resonate very broadly, not just in the anti-miscegenation cases such as Loving, which eventually got to the U.S. Supreme Court, but is resonating nowadays in a series of both the state-based and ultimately the federal challenges to exclusion from marriage for same-sex couples. But when the California court decided Perez, which involved a marriage between a Mexican-American woman and a black man, or an effort to marry, California civil rights organizations stayed away. They were very opposed to bringing this litigation. And indeed, if not for a particularly friendly and sympathetic group within the Catholic Archdiocese of Los Angeles, this case might not have been brought. But having then supported the Perezes in their efforts to get a declaration from the California Supreme Court that they had a right to marry without regard to their race or ethnicity, you then end up with really what's a quirk of fate, perhaps. And you can imagine how our constitutional doctrine and how our understanding of marriage and whether it is a fundamentally protected civil as well as human right could have taken a very different direction. Because the California court considered directly but rejected an argument that the right to marriage was an aspect of the free exercise of religion and religious beliefs, and therefore protected under the First Amendment to the Constitution. They said that the religious aspects of marriage were very important for lots of people, but they were separate and distinct from marriage within the United States, which was and always has been a civil institution, a creature of state law. Without the pronouncement by the state that a couple is legally married, marriage doesn't come into existence. And having then put aside the possibility of approaching an access to marriage question as a question of religious belief and concentrating instead on whether it was a civil right or a fundamental right protected under both the California and the federal Constitution, the court quite eloquently sort of summed it up, that the right to marry is as fundamental as the right to send one's child to a particular school or the right to have offspring. We're dealing with legislation that involves one of the basic civil rights of man. Marriage and procreation, fundamental to the very existence and survival of the race. I emphasize the and, because one of the contemporary issues, as many of you are well aware, in the marriage debate, is whether marriage and procreation are the same right. That is, whether the right to procreation is marriage-bound, and whether marriage is conditional upon the capacity to procreate, or whether without the capacity to procreate, marriage doesn't exist. But in fact, I think a careful parsing of a lot of these U.S. Supreme Court and also the California decision in Perez reveals a little bit of the ambiguity around the word and, but also the potential for there being two separate fundamental rights being acknowledged and recognized. A right to procreation, which in fact, when it first appeared in American constitutional doctrine, was a right recognized for a felon, a convicted felon in a prison in Oklahoma, who in an early version of 3 strikes and you're out, had been found guilty of 3 felonies, stealing chickens 3 times. And the penalty for a thrice convicted felon was castration. And for a variety of reasons, this case gets to the Supreme Court in 1943, and in part in explicit reaction to a sense of what was going on in Germany and in Europe in the 40s, the Supreme Court declares that there is a right of procreation that is so fundamental that you just can't go snip, snip to your thrice convicted felon. Yes?